going to talk about justice in Ukraine, and the topic of our next briefing is who hides in the details of changes to the constitution in terms of justice. We are going to hear Shepel, Reanimation package reform expert, Deputy Head of Arbitration Chamber of Ukraine, Tetiana Kozachenko, Director of Illustration of the Ministry of Justice of Ukraine, Agnieszka Piasecka, Support of Illustration and Justice Reform in Ukraine, Project Coordinator, the Open Dialogue Foundation, and Karl Volokh, civil activist. Also expecting Yemets to join us later, MP of Ukraine, Narodnyi Party, First Deputy Chairman of the Parliamentary Committee on Legal Policy and Justice. And Simkulis, you have the floor. Good afternoon. Thank you for the invitation extended to us to take part in this briefing. My name is Shepel, RPR. We are going to talk about the changes to be introduced in the Constitution in the realm of justice, which have been announced by our President in the beginning of this week. For some reasons, we are going to take care of the parallel briefing to explain what we agree with, what we would like to improve, and what hasn't been included or not taken into consideration those changes. We have started to actively talk about this reform 1 year ago, and the public activists and volunteers at this front, as we are. And then we had a big roundtable which gathered all the forces of the civil society, which represented the Maidan, and we actually would like to understand the expectation of people from the judicial reform. We had those big two words, lustration and combating corruption. Our forecast, we said that in order to achieve some success in the judicial reform, we needed at least 1 year to do something and to talk about. Then there were presidential elections, parliamentary elections, and as you know, neither reform can be carried out without the authority, at least legislative power. Then there was some kind of the judicial reform, and at the beginning of this year, they adopted the law for the restoration of confidence to the judicial power. We remember a lot of initiatives adopted by a reanimation package of reforms, and then in the form of the legislative initiatives proposed by the MPs, but they adopted the law on the just court, which actually took into consideration part of those proposals. And now we are talking about the changes to be introduced in the Constitution, which is the focus of our attention. Just think what reform is. We are talking about improvement of legislation, but not each improvement of legislation is reform. It doesn't spell reform. And those proposals made by the President, which actually meant to improve the legislation, but not of them can be considered reforms of combating the corruption as a consequence of that. The difference, major difference, according to the wording of presidents, they proposed the recertification of justice, and we would like to have the relaunch of the justice system, the reform the core of judges, where all candidates could be the existing judges or any other experts which would like to fill those vacancies. And the difference is really a principled one. We actually tried to provide illustrate that broadly. Remember the reform of militia, what was the consequence of that under Lutsenko, and the new police, which absolutely, from a quality point of view, is absolutely a new format. And in neither of the post-Soviet country, the judicial reform was smooth enough. And we understand that the judicial reforms in Poland and other countries took place in the 1990s. The latest experience in Bosnia and Herzegovina which took place in 2006-2007, actually speaks about the success of this process and the fact of failure of such a reform in reform recertification in other countries shows that we have to follow different road and to achieve some quality results. And the skeptics say where we are going to take 9,000 honest and principled people to fill those vacancies. This is kind of as if we spit in the face of the society. I believe we can find the 9,000, maybe less than that, because we are going to decrease the load on the judges who can fill those vacancies. We cannot but trust ourselves at this. And now we are going to address both the president and MPs, since this is the presidential initiative. Initiative is going to be submitted to the parliament for their consideration, so we have to include the demands of the society in order for the changes to be introduced in the constitution, become the basis for the rebooting of the, let's say, of the judicial system, and not allow those judges who work today to remain in their offices. We have to change the situation. The judicial authority or power in Ukraine is absent. The balance is the symbol of the judicial power, like the world over. If the balance is damaged, that means the judicial system doesn't work. So we do not have to provide a kind of facelift, and it will not help that. We have to recreate or create a new the system on this empty or vacant place where we are today. Thank you for your attention, and I give the floor to Tetiana.
They say very often about unique opportunities here, but in reality we have a chance to create a normal justice system. For 18 months nothing has happened in the country, and we know what sort of judges we have. We have two problems. First, non-transparent selection of judges for many years, and the second problem is a lack of any control and purification within the court system. We had higher councils of justice headed by Kivalov, Kolesnichenko, and Lukash, and so on, and it all depended on corruption and administrative and political influence. You cannot cook a good meal out of bad ingredients. Any reattestation and re-evaluation of the people who still work will not provide us with an opportunity to get away from the situation that we have. If we had judges that underwent transparent selection and independent court system, we would have a leverage of purification that will not allow to deprive people of freedom, to ruin their business, to snatch their property. All this has not only flourished in the country, but even now has not changed. This is why I am very happy that a lot of people, experts, specialists, judges and former judges of the Constitutional Court and a lot of MPs understand that in order to get a result, we have to reload the court system. And in order to do this, we have to provide an opportunity for a quality and transparent selection, so that people who will be trained will work on according to new standards. And those judges who do think that they are just can compete on the equal level. This is why we have to support the reloading of the court system if we have to have decent courts. Thank you. Hello, I am Agnieszka Piasecka. I represent Open Dialogue Foundation and also a group for court reform in the reanimation package of reforms. I'd like to tell you briefly why our foundation supports the idea for the reappointment of judges in a transparent way. As far as Poland is concerned, for 26 years we haven't done anything in order to readjust the court system, and for all those years only one judge was dismissed. So we had the same judges who adopted decisions against democratic opposition during communist times. Of course, part of the judges were changed because new people came to fill in their jobs. But if the system protects itself, you cannot just remove a judge from position, and there's a huge problem, and the trust in court system in Poland is very low. We have a very similar law in Poland, Germany, and France about the trust to the court system. This is like the principle that courts have to be independent, but if the judges cannot be fined or cannot be brought to criminal responsibility without special procedure, then they very arrogantly treat any citizens, including journalists and scientific researchers. As an analyst, I cannot check disciplinary decisions because they are closed and they do not have public access, and the access is very limited. So please do not repeat the way of Poland as far as the reform of the court system is concerned. As a citizen of Poland, I say that I hope that you will be successful and we will work together to this end. Thank you.
Good afternoon, Karl Volokh, the Public Lustration Committee. If you'll try today to discuss with the judges on topic what the status of justice in Ukraine, I can guarantee that they will say that not everything that as bad as you can imagine, that there is a number of very honest and very good judges, etc., but which doesn't tell and which is not reflected in the sociological the experience regarding the confidence or trust in judges, but they would say, the judge will say that this is inevitable. Always there will be somebody who is not satisfied or not happy, and they will tell you anything trying to prove that the situation is far from the tragic one which we believe it to be. In reality, we're talking about the real things. Let's take the events which took place in, let's say, a year and a half back, if you're talking about Maidan. If there were, well, look, actually we can talk 100% that if in this country there were justice, nothing would have happened to what happened. There won't be no expansion of the authorities in Yanukovych, there will be no this kind of robbery in the country or killing of the people. Actually, the courts had to prevent that and actually to defend their people. They did not do that. Recently I was speaking at the Congress of Judges. I was talking a lot of bad things there, and behind the scenes they told me, how can you actually generalize something and say that all of us, we are not honest, we are not decent? And I said, just take the statistics of the decisions or rulings you passed. How many people you put behind the bars, and how many cases which were politically motivated, and we are trying to praise those judges who were let go the people. They did not lose the criminal case. They were actually ruled a kind of home arrest for them and not put them behind the bars if you're talking about the cases which were politically motivated. Already those judges are like heroes to us. This is a realistic situation. Or another example. In Europe today, the percentage of the acquittals is about 25%. In Ukraine, 0.2%. Under Soviet times, we had 2% acquittals out of all the cases. So we are talking today, the prosecutors, the prosecution is powerful, you know, omnipotential. And I had the chance to be involved in the discussion when the judge said, "Why you said that we are bad guys?" I said, "Okay, what kind of court you represent? General jurisdiction. Can you imagine that every first person who you put behind the bars is actually from the very beginning, by default, is innocent person? Can you just imagine how many life sentences you already ruled?" And some strivings to change something in the judicial system. We adopted law on the right to just court. Let's not talk about some formal things. It doesn't matter to us whether there are 3 tiers or 4 tiers in the justice system in Ukraine, which is the last instance of cassation, instance. We would like to know that we have justice in our country. Take an objective criterion. Every judge is under pressure. Within 3 or whatever days, has to inform the Council of Judges, the prosecutor office, etc. How many addresses of this kind we have? Almost 0 all over the country. And then when they took care of the search in the Kozachenko home, they found the SMS messages with a number of names of different judges. He confessed that he received some instructions from the president, etc., etc. Were there any decision taken or rule taken based on that? Was at least one judge punished because this or another judge gave him instructions to pass this or another ruling? We know that this system is still alive in those systems. Nobody informs anybody about anything. So this is kind of the basis for the assessment of the judicial system. That's why this kind of cosmetic measures of facelifting should be considered those which fail to produce any result, not the law on confidence, on law on the renovation of trust in judges. This, again, if we are talking about the RPR, what is the proposal, we support them completely, and the number of the public activists didn't have time to put their signatures. I'm talking about MPs included. You know, this kind of information is spread very fast, and I do not want to do something instead of the government, but maybe you'll hear the other day, a few days from now, some of the key figures in our country, in government, that they support that, because we cannot create a country, a democratic country, without taking care of a fair judicial system in this country. So we do hope that there will be some changes and transformations for the better in the near future. Any questions? But before you do that, introduce yourselves, please. Well, everybody agrees that we have to reboot or to reload the courts. I'm sorry, I was late. Maybe you already mentioned that, but my question is, what would be the mechanism of selection during this rebooting? For example, like they did that in police, they take one portion, another tier, whatever else, and who are the judges? Who's going to select those judges?
A very essential question. It is a key question. It is a main question. We would be disappointed if this question was not asked. This is the difference between the changes that the president suggests and the public activists. The memorandum that we presented has been already signed by 46 public movements and almost 100 experts and representatives of the public, and we have thousands of citizens of Ukraine staying behind this. If we talk about reattestation that is provided for by the current law, and by the way, none of the judges has gone through the procedure within 6 months, the reappointment mechanism embraces everything up to reattestation. And I would tell the presidential administration, why are you against if your proposals are embraced by our proposals? Oh yes, there should be a certain temporary commission composed of former constitutional court justice and experts and public activists and the diaspora representatives who have unblemished reputation. Reattestation is a different procedure which will embrace just the current judges, and this is the key issue. We have to create anew the judges' corps. If we make independent the current judges, then we will conserve and preserve the corruption. But we can give independence to the new corps of justice, and they will be able to form a new High Council of Justice from mostly new judges. So I do repeat that we see the analogy in reattestation of police or the creation of new police. And we just suggest that there should be new court system, new courts, and new justice. And this should be done from above. According to our proposals, we want to reappoint judges from the Supreme Court and lower. We are for 3-level system which works everywhere in the world, but which is not there in the constitutional amendments suggested by the President. There is an example, such a reformation of the Supreme Court does not concern 9,000 judges, just 100. And this can be worked out by an independent commission composed of people that I mentioned. Why this is so important? Why we decided to start from the top? It is understandable that in this case we see a foolproof mechanism, a cassation body that will be very critical about first and second instance court's decisions, and this will really provide us with a very fast result, because thousands is one thing and 100 or 200 judges can be reappointed within a short period of time, and they will control the court system themselves. We think that this is the most logical way. Any other remarks? Sergei Kutnikov, the press service of a number of public organizations that deliver to the front line, and also the Man-Inform agency. If there's a process of stalling your initiative and active movements, what is your vision? How this can happen? What you suggest? You suggest that this happens very fast in the legal aspect and in practical aspect. I would not like today to speak about street actions and protests, as we have a very well-based, founded expectation that the highest political level of the country can support this idea. We have had such negotiations with certain political forces and the government. There's a serious hope, very serious hope, that this will be supported. If they don't, then any actions and public pressure, we do not discard anything Of course, this will be happening. We think that the issue is too serious and too important to be given away to the judgment of bureaucrats and to deprive the population of any influence.
I'd like to draw attention to the memorandum which we actually handed out to you. You see the signatories here. Present here at least representatives of two international organizations. I represent here International Chamber of Commerce. Agnieszka is not a Ukrainian citizen, she is a foreign volunteer. This memorandum is there will be a need to renovate the judiciary. The memorandum was supported by a number of international organizations who are also the reps of those organizations who are volunteers. Today, reps of the RP are going to have a meeting with a number of embassies. We are working with MPs. In parallel to our briefing, there's a number of different functions. Oksana Syroyid was meant to be here, but she's involved in a similar action. So unlike the situation which we had with the adoption of the law on the just court, we have a different situation. We don't have any other opportunity. This window of opportunities to change to introduce amendments into the Constitution. And neither us nor the foreign investors who are thinking whether to continue their work or not in Ukraine, we cannot let it go because this issue is too much topical. And one more thesis: let's not afraid to combat or to fight corruption. To create corruption schemes is much more difficult than to ruin those. We have to adopt a number of the legislative acts and laws and to change the mentality, not to give the bribes. As we can see in the case of the police, you can do that rather easy. You're talking about judiciary system. Seemingly we cannot find the experts, etc., etc. No, well, actually we can. We have to provide a very good selection and to teach those experts to select the judge. I mean, unlike the police, the requirements are a bit more specific and higher, and those judges who do not have the experience of working in the courts have to be trained. But we actually hope that we would get results 1 year ago. If we could launch that mechanism, that at least now we would have some kind of trained judge that we could present to the Supreme Court, to the Courts of Appeal. We cannot allow ourselves the luxury to lose those opportunities today. Do we understand that we need 1 year in order to have the pre-boot in judiciary? We are talking about the changes, amendments to be introduced into the Constitution. Second of all, it's not impossible to adopt such serious decisions in the country without the discussion with the society. This is not admissible. The public and the citizens have to know what's going on, and just to pretend that we are prepared to give this rotten system to reassess ourselves or reattest ourselves. This is to deprive ourselves of the opportunity to have the just courts. The country cannot survive for years without a just court. Speaking about reattestation or reassessment, they did that in the Nikolaev region. 200 employees, and 8 of those did not pass this reassessment. We'd like Emiliano Tetikov to go through this reattestation. If they fail to do that, they would be sent for the skills upgrading. And actually we deprive the possibility of those people who would like, honest people who really would like to work as judges, if they're honest. And so please go through the transparent and just election and be involved. Perhaps the system available today doesn't have any kind of credit of trust, but our people are so kind, but they're prepared to give this loan of credit of trust. Reattest the road police, and you'll see what we have. They give this credit of trust to the patrolmen, and they have to justify this trust. This is new training, new uniform, new format of work, and we are not talking that we are going to have something revolutionary evolutionary is the word. We do not mean that let's have the slogan, let's change or they replace all the judges. No, we would like to have the court which would be in conformity with the constitution. And what is proposed are this kind of facelifting, cosmetic changes which will not have any effect to our country. So we are talking not what has to be done, but what the mechanism can improve the problems we have. No, this cannot be overnight. This will take maybe 1 year, half a year, but we will not waste 10 years or decade when we'll have to come again to the same problem to have the just and fair court. And again, who is with you? We, all of us, we are together. So get involved in our work and all the rest of the citizens of the country. And we do not have time enough at all to see who can be involved. There is a memorandum, there is a mechanism how to do that, and we ask the public at large to be involved in this movement to maximum extent and provide new proposals which can be implemented and really do something about that. If we are introducing some amendments into the Constitution, if we can do that publicly and avoid the errors and mistakes, we have to do it now, because with every coming day we actually lose the future of our country. That is why this is our choice. Thank you. Maybe there are some final remarks, or there is a comment from the audience.
The proposal on the total reattestation, reselection of judges, but how many of the current judges do you see there? 0. Let's not work in schemes. We cannot tell you. We do foresee that everyone will be in equal conditions, and just experts in law and scientists and researchers and lawyers and judges who are working now, they all have to be in equal conditions, and practice will show how many of those who still work, who used to work, will get in there. But because the court system is very much closed, you could probably not find a judge who expresses their own opinion. In Ukraine, the trust towards the court system has decreased from 16% to 13%. This is the lowest in Europe and one of the lowest in the world. Well, of course, we can fall even lower. Statistics will sustain this, but will we? And there are no criteria, and the opportunities for everyone will be equal, but there has to be, of course, reputation checkup and property checkup and professional checkup. Of course, we want to raise the age limit and the lower threshold of the age. But let's not confuse improvement with the reform. Okay, then the issue of salaries. We can talk for a long time about all reappointment or reattestation, but if the salaries are not raised, then we will have a very fruitful soil for corruption. Thank you for my favorite question on this issue. A year ago, I've said that one of the, well, actually, the only source of the existence of the judge in this world has to be only their salary, apart from, of course, publication of their scientific work or teaching at a university. And the demands, the requests here, are rather different from public servants, because public servants who take bribes are not as dangerous as a judge who takes bribes, and they are even more dangerous than public servants who take bribes. So we want the judges to be provided money-wise so that they do not need any other source of income. But people also say that, for instance, teachers have low salaries, so whom we shall raise the salaries for if most of the judges are corrupt? And we have come to a compromise that the salaries will be raised when the judges will be appointed, reappointment of judges will happen. But even now, judges are among the most highly paid. If we talk about judges of high courts, they have a good level of salaries, even more than our ministers get. But this does not preclude them from being corrupt. And we still have two questions.
I'm a judge myself, Chuk Volodymyr, speaking about the topic of your briefing. The devil horizon. The details, I would like to talk about details, but first of all, I would like to say that I support this idea because despite its radicalism, can rather quickly obtain some results. So your work is not futile, and in order for this work not to be futile, we have to take into consideration details as well. So speaking about the details, which I'm interested in, who is going to form the committee or commission who will take care of the selection and the appointment. I have 4 questions actually. I already mentioned that. Who is going to be on the committee? Do you need the names or? You mentioned that some approach, there will be some specific citizens of Ukraine who are going to appoint the members of that committee. I already mentioned the provisions made for the setting up of the temporary body which will take care of this kind of rebooting. Again, no, I'm interested not who will be on the composition, who's going to elect those members of committee, how are going to find those members or would-be members of committee. Actually, there are mechanisms in some of the laws today. How specifically it will take place, we can say that this will be like in the law on preventing corruption or the law on the corruption bureau. This is very difficult to say today, but I understand that partially it must be, we must involve the Verkhovna Rada, maybe the president, maybe the government, maybe some of the public organizations which prove to be involved specifically in this issue. This is not the issue of principle, but you know that recently we had a similar problem. Well, we understand who will be exactly, how many members of that first commission who is going to take care of selection. Will it be appointed by the president of Verkhovna Rada? So we didn't think about that yet. No. In this case, we are not talking about this decision. Decision will be taken, but if the recommendation will be adopted per se, then to talk, or let's say to decide who is going to appoint those people, it's not a difficult task. Now, the body which is responsible for the selection of the judges, there is a special chamber actually, which is formed on the principle which you mentioned, partial by the Verkhovna Rada, partial by the president, by the let's say by the prosecutor's office or prosecutors or the judges. So in which respect the commission or committee which you propose to have will be better as compared to the existing ones, because the assessment committee or qualification committee started to work some time ago after Maidan. Why you do not trust that committee and you have confidence in the organ or the commission which is going to be set up according to your proposal? Why we do not trust that commission? The answer to that lies in this plane of sociological polling. There was why you do not trust the judiciary. There was kind of administrative influence, corruption, dependence on oligarchs, etc., etc. In general, lack of confidence in the judiciary, generally speaking. And we are talking about those bodies which are going to take care of reattestation or reassessment of the judges. And why we need this kind of temporary or interim committee because there will be access of the public at large, and those people who I mentioned represents of diaspora and foreign courts, those who have the Ukrainian origin. As for the Constitutional Court, we do not take the people from the street. The major principle is availability of the high repute, or reputation, high moral qualities, and we are talking about not those existing judges because of the reason which I mentioned, low confidence in those. No, this is not the major reason. If you are talking about the composition of the existing committee, RPR, do not actually trust that idea. No, this is wrong. This is wrong. You're asking technical questions which we have to work on in order to achieve the objective we set ourselves. We have some of the results. We want to have this specific certain court with a certain composition of judges. The higher judicial court have not worked for a year. There is a huge load upon them. The results which they demonstrate today are very impressive, and there are no objections to them regarding the procedure of their work or their composition of that committee. But we are not talking about this set or the selection of the judges, which including the disciplinary, let's say, we are talking about that we have to reconstruct the whole system and to renovate the confidence on the part of the society, among other things. And again, we are going to have a new, absolutely new format, that this committee will enable us to involve to some a certain function the complete reselection and not just specific one judge. We have to reboot the system. In order to do that, we have to avoid the problems so that we have to provide justice in this country. So the higher Council of Justice have to do something. But we are talking not about the reselection or re-election one, two judges. We are talking about the rebooting the whole system. A number of different guys who are going to be selected of the society, and we have to see how those procedures take place or process take place. And not only we have to the higher qualification committee, also to involve the experts, international experts, to reformat the body, which we do not have the grounds to change the existing committee, but we have to ensure the transparency of these agents of the body. And if you're talking about the higher Council of Justice, they have to be involved so that the bodies which exist today have to come up with those proposals how to achieve that.
Maybe you should add some new candidates to the Higher Qualification Commission, and it will perform such functions. Any proposal can be regarded and considered, but if we talk about complete reloading, this has to be something new. Okay, let those bodies work. We won't be able to restructure this within one day. As a result of this reloading, by the way, as opposed to qualification reattachment, you suggest that a judge should be dismissed. No. The judges are dismissed at first and then they get their jobs. What is the legal foundation for this that might be in the Constitution? We are talking about amendments in the Constitution. I am a member of the Constitutional Commission. Where have we gone wrong? What is the foundation to stop the authority of a judge that has to be written in the Constitution? We are very pleased that you are a member of the Constitutional Commission that gathered yesterday, as far as I know. We have submitted such proposals. I have not taken the text to the meeting with journalists, but you might have been acquainted with those proposals. It is the state that forms the order and regulation of state bodies. The building of state bodies and selecting personnel for them is the right of the state. This is not just dismissing the judges from three-level system, but this is a building of a new system according to the functions that belong to the state. That's all. By the way, in the infographics you have to see the answer to this question. If there is a negative result, then this person cannot be appointed a judge, and if they are a judge at the moment, they should be dismissed. This is the rebuilding, reconstruction, territorially and specifically, and the area of responsibility. In reality, these discussions are very important. We have to decide whether we want to have new courts or not. Okay, you've given the information. Let's move the discussion to another place. Thank you very much for having come. We'll come back to this issue. The working day for today is